Hey, what's going on, everybody? Welcome back. Now, this is the final video in the series that takes a look at Heather Williams' civil claim against R. Kelly. Now, as I predicted in the previous videos, he has filed, R. Kelly has filed a 21301. I think I said in the previous videos that he could have filed a 21301 or 21401. He's chosen to go with the 21301. I looked at his 21301 and I talked about it in early in this series. I think he actually missed a few arguments that he could have had in the 21301, but nonetheless, I think he's going to be good to go with his 21301 because he's basically saying number one, he never received the summons, and then number two, what he did receive, he couldn't read, and then number three, the plaintiffs had the option of actually providing this information over to his criminal lawyer, who could have notified R. Kelly of his court summons to the civil case, but they failed to do so. So, given that, they're asking the judge to vacate the default judgment because substantial justice would not be done. And the arguments look plausible. I think he's going to get it. So now, after the judgment is vacated, R. Kelly has to file a response to Heather Williams' original claim. Now, as I see it, untrained eyes, I'm not a lawyer. I didn't go to law school. I'm not licensed to practice law. As I see it off the top of my head and without knowing the detail, R. Kelly has about 10 possible arguments to counter Heather Williams' civil claim. So we're going to get into these 10 possible arguments. So let's just go ahead and get into it now. Now, I don't know what has happened between R. Kelly and Heather Williams, but to me, if R. Kelly has not had sex with Heather Williams, then the most obvious defense is to come out and say Heather Williams is not or was not my lover. Okay, so that's the most obvious thing to do. Now, obviously, she's going to refute that, but it has to be proven. She has to prove that she has had sex with him. And by this case being so old, that's going to be hard to do. Now, another obvious argument that he could potentially make, he can just come out and he can just say, look, this is really old stuff. She is alleging that this happened in 1998. It's 2019. This is old garbage, right? It's old garbage. It's going to be impossible for us to go back and review the details of something that happened in 1998. Now, when he makes this argument, he's appealing to the human side of the jury and not necessarily making any arguments based on the merits of the case, right? So if this is a really good argument in the event that he gets a jury, and he's just coming out and just saying, look, this is old garbage. And you're basically trying to litigate something that's so old, and it's going to be impossible to go back and rehash all the details of how, this thing came to be. So the third possible argument that R. Kelly and his lawyers could make is that they could essentially come out and say the version of the statute that the plaintiffs are using do not apply, or you can't apply them, right? Now, I have that version of the statute, and I've talked about it in previous videos. It's basically Chapter 735, Illinois Compiled Statutes, Section 5/13-202. Okay, and it's essentially known as the Childhood Sexual Abuse Statute. Now, I did go in detail about this statute in previous videos, and if you want to know what I said, you can basically go back and watch those videos. But the reason we're revisiting it is because of this section here, Section F, right? So basically, let me read this section before I get into it. Let me read it. And it basically goes on to say, notwithstanding any other provision of law, an action for damages based on child sexual abuse may be commenced at any time, provided, however, that the changes made by this amendatory act of the 98th General Assembly apply to the actions commenced on or after the effective date of this amendatory act of the 98th General Assembly. If the actions would not have been time barred under any statute of limitations or statute of repose prior to the effective date of this amendatory act of the 98th General Assembly. Now, basically, it's telling you right here that you can bring this claim if the event happened, and this is the way I interpret it. It's saying you can bring this claim if the event happened on or after this statute became officially law. If the actions happened before this statute became law, essentially a later version of the statute applies. So let me be a little clear, because this is an old statute. It's been around for a while, but it's been amended several times. And that's essentially what this thing is telling you. It's basically telling you we've amended this statute. This is the most recent version. If the event happened, right? So it basically says applies to the actions commenced on or after the effective date of this amendatory act, right? So if the event happened on the day or after after any time after this thing became officially, this version actually became officially law, then you can use this act. If not, you have to use an older version. Now, here's the thing. I have done some research on this statute, and I know that previous versions of this statute does have a smaller window of opportunity for the plaintiff to bring a claim. So if this version doesn't apply, they will be forced to use an older version, which has a smaller window and which, in no doubt, is going to not be able to qualify them because their time have simply run out. So essentially, to be honest with you, I think this is going to be the silver bullet that R. Kelly and his lawyers can shoot to basically kill this case. Or you can just say it's going to be the coup de grace, because basically this case is based on a new version of the statute, and this statute probably simply does not apply to something that happened in 1998. I'm going to be willing to bet that the older version of the statute is going to apply, and the older version of the statute will probably have a smaller window. The fourth argument R. Kelly could make, or actually the fourth thing that he could do to fight this case, is to bring in his own psychiatrist or psychologist. I'm not in the medical field, but I think that the difference between a psychologist and a psychiatrist is that one is able to prescribe medicine, the psychiatrist, and the psychologist cannot. So he can bring in either his own psychiatrist or psychologist. And the reason he would want to do this is because when you listen to the story, when you read the plaintiff's argument, Heather Williams' argument a couple of times, you realize that it starts to not make any sense, right? But you simply just can't come out and say it doesn't make any sense. You have to bring in a medical expert to essentially counter the argument that the plaintiff is making with her medical expert. But it doesn't make any sense because you're saying this all started in 1998, and you're saying that your mother met R. Kelly and you started to have a sexual relationship with R. Kelly. But nowhere in the brief do you say that R. Kelly forced himself onto you or he made you have sex with him. He put a gun to your head. You didn't mention any of that, right? So I believe, based on what Heather Williams has already provided, that she had a relationship with R. Kelly for monetary reasons, either monetary reasons or she actually liked it. And if you had a relationship with someone based on monetary reasons or because you enjoyed the relationships or you enjoyed the sex, then it's going to be impossible for me to believe that you're having these dramatic, repressed memories of having sex with them. And in my mind, you would have these repressed memories or these dramatic outbreaks or episodes if you were violently raped. Now, I don't want to get too much in that now because actually, I think towards the end, I have another argument that involves rape. But I'm just going to essentially say it's hard to believe that you're having repressed memories of a relationship that you had based on money or based on something that you enjoyed. Like it just doesn't make sense. So I think R. Kelly has to bring in his own psychiatrist, or he has to bring in his own psychologist, whatever expert he chooses to pick, or his own therapist to come in and look at some of the evidence, the the medical evidence. I don't know what to call it. I think maybe forensic medical evidence that they're using to make this claim, because to me, offhand, it just doesn't make sense. But the fifth thing that he could do is that he can actually, well, he should ask the judge to pause this thing, to postpone it, to pause it, whatever you want to call it. He should ask to postpone or pause it until the outcome of the criminal case is decided. Now, I've actually done some research. I came across some case law or an article, I can't remember which, but basically the gist of it was that when a plaintiff is involved in both a civil claim as well as a criminal claim against a defendant, the criminal claim has to come first. And if you, or the criminal proceedings, I'm sorry, the criminal proceedings would have to come first. And if you think about it, it kind of makes sense, because if you allow the civil case to go forward first, naturally things out of the civil trial are going to come out that would basically impact the criminal trial, right? It's only natural. And it's really guaranteed in this situation, because you have the victim who's in the criminal case. She's trying to sue him in a civil courtroom, and basically she's going to have to testify in terms of what happened. Now that's going to cause all types of, I guess, constitutional violations in the criminal trial. In my mind, one of the possible arguments that would pop up is double jeopardy, because essentially you're having this civil case, and in order to have that civil case, you have to basically argue that she was raped to begin with, right? To me, there's a lot of things that's wrong with having the civil trial before the criminal trial, and I'm pretty sure that the judge is likely to agree, and more than likely the judge is going to say, okay, we're just going to pause this and or postpone it and wait until the criminal proceedings is finished, and then we'll come back. Now the flip side of that is that if that actually happens and the judge allows R. Kelly to postpone it, and then they have the criminal case and he lose the criminal case, well, then it's an automatic loss in the civil case, right? Because basically, criminally, he's already been found guilty of raping this woman. So now, when it comes down to the civil portion, it's not really a question of whether or not he raped her. It's more about how much is to be awarded, right? So if you just think about that right there, that is basically a reason that you really want to postpone this case until the criminal proceedings are basically finished. Because like I said, if you have the civil case before, and it's probably better for the plaintiff too. Uh, if you have this case before the criminal trial, then the plaintiff has to prove that R. Kelly committed sexual abuse. She has to prove it beforehand, right? Whereas the criminal trial would automatically do that for her, right? If she wins the criminal trial, then it's going to be automatically proven that R. Kelly has basically sexually abused her. And to be honest with you, I'm not really quite sure why they are attempting to actually sue before the criminal proceedings have completed. One possibility could be that maybe they don't believe the criminal case will even get off the ground, so therefore they want to make sure that they attack him on the civil front. And then another, I guess, school of thought is that, okay, well, we have this criminal thing going. Let's just go ahead and put the civil case in first before anyone else comes along and actually makes a claim against them. We want to have first dibs, or we want to get a claim in as soon as possible before someone else comes along and basically makes the same claim. I don't know. To me, it didn't really make sense to file this civil claim before the criminal proceedings have finished, but I don't know. Let me know what you guys think. Now, the sixth argument that R. Kelly can make has to do with diligence. Now, in order for us to get into that, we have to go back to the statute, which is, as you know by now, Chapter 735, Illinois Compiled Statute, Section 513-202.2, known as the Childhood Sexual Abuse Statute. Now, this argument has more to do with diligence and it's a little creative. I'm not sure how well received such an argument would be when it comes down to the court. I don't necessarily have case law on this. So, by there not being any case law, maybe a judge would not find this a legitimate argument, but the jury would, right? The jury hearing this argument would basically find it legitimate. Basically, the statute talks about diligence and it mentions diligence several times. So let me just go ahead and read one section where it mentions diligence. Notwithstanding any other provision of law, an action for damages for personal injury based on childhood sexual abuse must be commenced within 20 years of the date the limitation period begins to run under subsection D, or within 20 years of the date the person abused discover or through the use of reasonable diligence should discover both, so on and so forth, right? So there's that word diligence. So R. Kelly can come out and say that the parents of Heather Williams were not diligent because if they were diligent, they would have known or should have known that the relationship between R. Kelly and Heather Williams could have a serious psychological impact. Now, again, this is based on certain facts. It's based on the fact that, or it presumes that the mother and the father knew that Heather Williams had a sexual relationship with R. Kelly. And I believe that's believable because now this presumes that the parents knew about the relationship and the parents consented to the relationship. Now, I know in 1998, there were a lot of parents that would consent to a child being 16 and up, sleeping around with a older man or older woman. They would typically say things like, that's between him and her, so on and so forth. Now, I'm not saying that it's morally right. I'm not advising any parent to do that. I certainly wouldn't do that. But I'm just saying, around 1998, I've heard this type of talk. And it's believable that the parents of Heather Williams knew about the relationship between R. Kelly and Heather. So if this is the case, then they should have known that it would have some psychological impacts on Heather Williams when she became an adult. So that's one argument that she could potentially make. Again, an argument like this is not going to fly probably with the judge, who's probably going to follow the statute to its higher degree of strictness. But in terms of appealing to the jury, I think it could basically work with the jury. I think it would be a winning argument with the jury. They can say, hey, look, the parents knew about it. The parents should have known and they should have been diligent to basically put a stop to this or not condone it in the first place. So don't sue me, sue your mom. The seventh possible argument that they could potentially make or R. Kelly could make in court is that they could come forth and say, hey, they've already threatened to sue in the past. I paid them to prevent suing. We settled out of court. I gave them X amount of dollars. And, that should be the end of it. So they shouldn't be allowed to basically bring this forth again. Uh, there are legal doctrines that could apply, like estoppel by convention or equitable estoppel, possibly. It's kind of tricky because this is a sexual abuse case, a childhood sexual abuse case. But essentially, if they've come to R. Kelly and they say, you know what, you've been sleeping with my daughter for over a year and we just found out, we're going to take you to court and sue you. R. Kelly comes out, he says, wait, I'll pay you, I'll give you some money. Please don't take this to court. And they accept that money. Then he can argue that basically this has already been resolved, right? I think that's going to be there's lots of estoppel doctrines. I think one of them could be equitable estoppel, right, or estoppel by convention, which is essentially saying that, well, hey, we've already agreed that this issue was going to be taken care of. I gave them X amount of money, so they shouldn't be able to come back and relitigate this. So the eighth argument that R. Kelly could potentially make may not actually be available to him. But I mention it because I know that several cases have been brought against R. Kelly that were dismissed before, or they refused to bring it forth. If this case was already brought in the past and it was defeated or thrown out, then res judicata would apply. If Heather Williams was involved in the first case, and that case was, as you all know, it has been thrown out, then they could potentially argue res judicata. Now, again, I don't think it's likely that she's brought this claim before because I haven't heard of it, but there is a chance that it was brought in some back of the woods courtroom or some through some back alley court proceeding that no one heard about, and the case was dismissed, or it could have been involved in the first case when he was on trial for, I think, taking videos of a minor or something like that, and it was thrown out. Then res judicata would apply, and this case should be dismissed. But again, I don't think it's likely because I haven't heard of Heather Williams before, and I think everyone would know if she's brought this claim before. But I thought it'd be good to mention it just in case because I don't know all the details. And I don't know if I can't say for sure if this has basically been brought to court before and decided on. So res judicata could apply if it has. The ninth argument that R. Kelly and his lawyers could potentially make is the doctrine of unclean hands. So basically, the doctrine of unclean hands says that you can't go to court to take advantage of your own wrong. That's essentially what the doctrine says. So R. Kelly can come out and say, well, look, the mother and the father knew about this relationship, right? Not only did they know about it, but they promoted it. So I think this claim should be barred because both the mother and the father knew about the relationship, and not only did they know about it, they promoted it. And at the time, Heather was into the relationship. Now I'm saying this, but to be honest with you, I don't know whether or not they actually knew about the relationship. The plaintiff's brief or claim basically says that the mother and the father met with R. Kelly for dinner with along with Heather Williams. So it's hard for me to believe that he was sleeping with her all this time and the parents not to have known something that was going on. If there was a situation where the mother and father knew about it, but they just simply didn't care because R. Kelly was giving both Heather and the mother and father gifts and money, then the doctrine of unclean hands definitely applies because they consented to an immoral relationship and the daughter knew it was likely immoral, should have known from her parents that it was immoral. The fact that the daughter did not know the relationship was immoral doesn't really mean anything because she should have known, her parents should have told her so. So if they knew, he can make a legitimate claim of unclean hands, and the plaintiffs or Heather Williams' claim should be dismissed based on unclean hands. Now, the tenth argument that R. Kelly can make is that he can actually come out and actually say that there was no rape. Now, I want to be careful with this. I'm not saying that it's okay to have sex with underage children. I'm definitely not saying that. I'm not making that argument, and I don't condone that type of action. But I would say in this situation that R. Kelly could argue that there is a difference between a rape, where in the sense that someone is being forced or held down against their will and forced to have sex, versus someone who basically consented to having sex. Now, again, we know that minors can't consent to having sex, but I want to just put that aside for now, right? Just put it aside for a second and just consider the fact that there is a big difference between someone being held at gunpoint or someone being overpowered and forced into having sex when they really didn't want to. Here, it's a little different. It is a minor, but we're putting that aside, and we're basically just highlighting the difference between someone who wants to have sex versus someone who was forced into it. And when you look at it from that perspective, you'll find that this case simply just doesn't make sense, right? Now, obviously, this isn't an argument that you want to make towards a judge, right? You don't want an argument. The judge is going to be forced to actually go by the book, and he basically wouldn't hear any of this. And then, not only that, I think there is something called a what is this thing called? There's something called strict liability, and that essentially means that no matter what the defendant says, he is liable uh, for his actions when he has sex with minors. I think there's certain cases where, or certain situations where you're guilty no matter what, right? So by the book, yes, he would be guilty no matter what, and Heather could basically be awarded damages. But setting aside that she was 16, just set it aside just for a second. If you do that, you'll see that this makes no sense. It makes absolutely no sense because his her mother and her father knew about R. Kelly. I don't know if they knew about the sexual relationship, but it's going to be hard to believe that she was with R. Kelly for over a year, because I think her brief says that she met R. Kelly in 1998. Then she had dinner with her and R. Kelly and her parents, and their sexual relationship continued for at least a year, right? So it's hard for me to believe that two parents wouldn't know that their child is having sex, right? I mean, how are you not paying attention when your daughter, are you allowing your daughter to go back and forth to the studio alone? Like, how does this happen? So it's hard for me to believe that the parents didn't know or didn't suspect. So when you put it in that light, you'll find that it really just doesn't make any sense. And R. Kelly could appeal to the jury, or his lawyer could appeal to the jury and look, her parents knew that she was having sex with R. Kelly. She consented to having sex with R. Kelly. He didn't force her. He didn't put a gun to her head. Yes, she was a child, but let's put that aside. He didn't force her. He didn't hold her down. He didn't put a gun to her head. He didn't do anything of that nature. She did it of her own free will. And as I argued before, it's going to be hard to believe that you're having repressed memories when you had sex by choice. You actually had sex by choice. So it's the repressed memory thing just doesn't fly. So none of this makes sense. It makes absolutely no sense that she's having repressed memories. Again, we're going to set aside that she was a minor and just focus on the relationship they had. They had a consensual sexual relationship. From reading the Heather's brief, they had a consensual sexual relationship. The brief doesn't convince me to say that she didn't want to have this relationship, because the relationship spanned it over a year, and she didn't have to continue to meet with R. Kelly. She met with him because she wanted to. And I also have to figure out, or I have to come to terms with how her parents played a role, because I wouldn't let my child meet with a grown man in the studio, by herself, right? The only way that that's actually going to happen is if I'm present or her mom is present. So this really just doesn't make any sense. It's hard for me to believe that she didn't consent to this, and it's very hard for me to believe that the parents didn't consent to this. So I think R. Kelly's lawyer could definitely make an appeal to the jury. A judge probably wouldn't buy this, right? But a jury would see the human aspects of this, and they would see this situation. If you set aside the fact that she was 16 just for a moment, just set it aside. You set that aside, and you'll see that none of this makes any sense whatsoever. simply because she engaged in this relationship for over a year. And again, it's going to be hard to convince a jury that she was sexually abused when this went on for a year. And it's likely that her parents knew about this relationship, and it's likely that she consented to it. And the reason I say I think that Heather consented to it because she met him obviously repeatedly for a year. I don't, from reading the brief, I don't see where in the brief that it indicates, or at least from a believable perspective, or makes it believable that he was, stalking her, running her down and, just catching her and then forcing her to have sex. I don't see this. I don't see this as rape. It's statutory rape for sure because she was underage, but I think there's a huge difference from a brutal or forceful rape as compared to statutory rape. I think there's a huge difference, right? Now, I know that there are some laws that are considered strict liability. You're guilty no matter what. So, in that sense, then he automatically loses, right? Because he's guilty of having sex with a minor if he actually had sex with her, right? But I don't see how a jury is going to believe that she's having these repressed memories, right, from something that she consented to and she did willingly. Because to me it looks like it went on for a year. And it's just hard for me to believe it. It is just really hard for me to believe it. So, that's it. That's all I have. We'll see what happens. We'll see what R. Kelly actually puts in his actual claim. And I think that he has a decent chance of actually beating this. Like I said, I'm not a lawyer. I'm not, licensed to practice law. I didn't go to law school, so I don't really know. And obviously, I don't know if any of these arguments are going to hold up in the court. But by all means, leave comments below and definitely let me know what you think.